Good afternoon and welcome to today's presentation, Ethics for Lawyers, using Facebook, Twitter, and LinkedIn for legal marketing. Before we begin our presentation today, I would like to take a few moments to go over some housekeeping items. We will be recording this webinar, and this webinar is CLE approved, and we will be asking that you enter a passcode for CLE credit a few times throughout the presentation. In today's webinar, Ms. Ellis will discuss how to use Facebook, Twitter, and LinkedIn for legal marketing, intent of social media marketing, advertising rules, best practices, and ethical issues that may arise when promoting a law firm on social media. To give you a little background about our presenter, Jennifer Ellis, she is an attorney with the firm Lowenthal & Abrams, where she practices legal malpractice and ethics. She also manages the firm's online presence. Jennifer is a frequent author and speaker and is recognized nationally for her knowledge on legal ethics. She speaks and writes on issues including social media, legal ethics, and technology for law firms. Jennifer wrote the book, WordPress in 1 Hour for Lawyers, and the chapter on social media for both the 2013 and 2014 American Bar Association Solo and Small Firm Legal Technology Guide. Jennifer also serves as a law practice management consultant where she helps attorneys improve the efficiency of their practices and assists with websites on marketing. For those of our attendees who require a code word for tracking purposes, the code word for today is ethics. During the presentation, we will take short breaks, and during that time, we will ask that you enter this code into the chat feature for CLE reporting purposes. The chat feature is located to the right of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself. If you have attempted to log on and received an error, or if you are listening via telephone, please email the passcode both times that is requested, and please state the time that you have entered your code in your email. Also, please remember to complete the survey that will appear on your screen at the end of the presentation. As a provider of CLE credits, we are required to have supportive information that you have attended, and in many states the survey is required. Ms. Ellis welcomes your questions. Please use the chat feature to submit your questions throughout the presentation. We will take intermittent breaks so that Ms. Ellis can respond. Thank you all again for attending today, and Jennifer, the presentation is now turned over to you.
Thank you very much, and thank you for having me today, and to all of you who have decided to spend the next hour with me. I very much appreciate it. So the first thing I'd like to talk to people about when we get into concepts surrounding social media is the web generally. When we talk about the Internet, you have to think of it for lawyer marketing as a networking tool, an advertising medium, and it's your relationship online. When you search someone's name online, you search my name online, for example, you're going to learn quite a bit about me. Some of it professionally related, some of it personally related, and I am very careful to do what I can to control my reputation online. Now, it's not possible for me to control every little thing, but I am very conscious of what I post. You remember when we went to law school, they said, look to your left, look to your right, one of you will be gone. And the other thing they said is that your reputation is all you have, and that's true. Reputations are formed over years and destroyed on the web in moments. It was interesting, I was listening to the radio this morning, and Monica Lewinsky was speaking, and she talked about how that she was the first person who had her reputation destroyed by the Internet. And that's probably true. She was very young, and the Internet wasn't being used the way it is now. But the Drudge Report and other sites really did go after her, and it's only gotten worse since then, which is extraordinary to think. Ethically speaking, we do have an obligation to maintain the integrity of the profession. So if you do something inappropriate, you could end up in ethical trouble under your disciplinary board. And when we talk about viral, of course, that means that something just kind of spreads across the Internet in an organic fashion. And viral can be positive and it can be negative. And negative viral stuff can be really, really difficult to deal with, whether it's for your clients or for you. The main thing you want to think about when you're talking about the web is you want to be easy to find. That means you need to have a website. If you don't have a website, the first thing you should do when you go back and you create a marketing plan for yourself is to look into creating one as soon as possible. On that website or separate from that website, whichever you prefer, you should have a blog, and on that blog you should write high-quality content. The content can be about your practice area. It can be about other things you're interested in sharing. It can be about any good works that your firm does or you do. It can be broad, but you want to write at least some of the time about your practice and your areas of practice. Google Plus has not really worked particularly well as a social media site, but it's very useful for search engine optimization, and I commend it to you for that reason. Search engine optimization, SEO, when people talk about that, they mean how people organically find you on Google on the search engine results page. Facebook, of course, we have well over 1 billion people using it now, hundreds of millions of people in the United States, so it's very important to have a presence there. LinkedIn, every lawyer should have a profile on LinkedIn. There's no real harm in having one. You do, of course, want to be conscious of your interactions. Twitter, eventually microblogging, again, a great way to expand your reach on the web. And there are many, many other sites you can use. When we talk about ethics and technology, there's sort of a thing sweeping across the nation that began with the American Bar Association called Ethics 2020. And the purpose of Ethics 2020 was to adjust the ethics rules as they relate to technology. And most states have begun to add the concept of confidence with technology to their rules. And by that they mean you have to keep abreast of changes in the law and its practice. We've always had to do that. What's been added, especially to Pennsylvania where I'm practicing, is including the benefits and risks associated with relevant technology. Well, what does that mean? It doesn't mean you need to become an expert in technology. What it does mean is that you need to be aware of the types of technology that are important for your practice, and you need to be confident in using them. And it means that if you're going to use technology, including social media, you must be confident in your use of it. Therefore, ignorance of the ethics rules related to your use of social media won't cut it. On top of that, I would add, and this is somewhat outside the confines of the seminar, that social media has become very important in litigation. There's a lot of evidence there, and especially in certain areas of practice, I think a failure to research the opposing side might be malpractice. For example, a lot of the time defense counsel will look at the publicly available information on Facebook that a victim of a car accident might post to see if the person really is as injured as he or she says they are. So these are some of the sorts of things you need to think about when you get into using social media. If you don't feel that you are confident in it, I would say it's your obligation to become confident and or to retain somebody who will help you become confident and who makes sure that you are using it appropriately for your practice, both ethically and in terms of your legal practice itself. When we're talking about marketing, the first question is social media marketing? And I think that it's not a straightforward answer. Sometimes use of social media is marketing, and sometimes it isn't. Marketing is the action or business of promoting and selling products or services. Now, when I post something on social media, I may be marketing myself or my firm, or I may just be having a conversation. So sometimes it's marketing, sometimes it's not. What we could overall say that I began my social media presence with no purpose of marketing. I did it because a friend asked me to get onto Facebook, so I did. But then over the years, I began to see the potential for marketing on social media, and I have since had an eye there. So what is my intent? Well, it varies. So if I'm directly seeking a client, if I'm sharing a blog post about legal malpractice or medical malpractice, that's marketing. If I'm providing broad educational information, that's probably not marketing, but that's where the line becomes blurry. If I'm talking about my dog running away from me, that's definitely not marketing, but it does act as a way of networking. So in the end, what I say that people should do is you want to assume everything is marketing, and you want to follow the rules, which are generally 7.2 under the ABA, And also you want to make sure you follow rules for all states in which you are licensed or anyone from your firm is licensed or in which you're seeking clients. So there's a couple of ways you can sort of watch out for that. The first thing is you always want to be honest. Under Rule 7.1, you must be honest. There's no false or misleading communication, no material misrepresentation of facts or law. You just have to make sure that you are fundamentally honest in any of your marketing communications. So we kind of jumped to Twitter here, but let's look at Twitter briefly. I think this is a slide that's out of order, actually. Okay, well, I'll just have to follow it. I didn't organize all these slides. So let's move on to Twitter. Twitter is a form of marketing that you can use. It's also just a form of communication. A colleague of mine really built a career for herself using Twitter, communicating not only about her work, which happens to be a tax law, but about her family and her life in general. And she's built quite a following and developed quite a career as a tax lawyer out of it. A lot of people like Twitter, and about 75% of people don't actually post anything on Twitter. Most people who are on Twitter just read what other people post. So because you can only use 140 characters, Twitter is what we call microblogging. It's a great way to share little bits of information about yourself, about your firm. You want to reshare what other people are posting. It's a great way to not only share information about yourself, but to share useful information. That might be from other non-competitor law firms. It might be interesting articles for the New York Times or the Washington Post. It might be commenting on what the weather is like outside. Twitter is very informal. The main thing when we're talking about any form of social media, including Twitter, is that it's very crucial to attempt to engage with other people. This is not a newsletter. It's supposed to be 2, 3, 4 way, and you want to make sure that that's what you're doing. You're trying to engage other people. On Twitter, there's a special kind of a language and a special way of using it. You have replies, you have favorites, you have follows, and you have retweets. A reply is when somebody says something and you respond. A favorite is when somebody, and you can see the image here, somebody favorited that tweet. A favorite essentially is a saving of something or a liking of something. When someone follows you, that means they automatically see your tweet. And a retweet is when you share a tweet someone else did. So if I post a tweet, Jennifer Ellis is doing a seminar today on social media, and someone else retweets it, that means not only do all of my followers see that tweet, but all of the other person's followers do as well. And in fact, somebody did that. I tweeted that I was going to be doing this presentation, and somebody retweeted it, and then I replied, "Thank you for tweeting." So that's a typical kind of a conversation. Twitter has a special language, so a lot of the time, one way you can minimize your effort and maximize your time is to automatically share from one site to another. I generally recommend that you be careful sharing directly from Twitter to other places because Twitter uses its own language. Twitter uses hashtags, that's the #, so it would be hashtag social media might be the right hashtag for that. And how these hashtags work is if everybody's discussing the same topic, they'll hashtag it so that you can then follow along and search for exactly that same hashtag. So, for example, with the elections coming up here in Pennsylvania, you might have hashtag Pennsylvania governor race. Then everybody who's talking about the governor race will share using that hashtag so everybody can keep track of what everybody else is doing. RT stands for retweet. You have a handle that's always followed by the @ or @JLE_JD. That's me. If you want to get my attention, you tweet it to me using my handle. And again, you have to abbreviate language, so it can end up looking almost more like a text than formal language. Best practices for Twitter, you want to share other people's stuff. The only way people are really going to share your stuff is if you share theirs. You know, they'll scratch their back and they'll scratch yours. Always give credit where credit is due. Don't eliminate the appropriate handle to give credit because you don't have enough space. It's very important to give credit. Thank people when they interact with you and complete your thoughts. Let's say you're sharing a post from Facebook to Twitter. very frequently, because you can use so many more characters on Facebook, it'll get cut off when you share it to Twitter. You have to think about that. You have to make sure you give a complete thought in every tweet. Use hashtags that make sense. Sometimes people will use hashtags to be funny, and that's fine, but you also want to use hashtags that will help people find whatever it is you're talking about. So if I'm talking about medical malpractice, I might use hashtag MedMal. Humor is fine on Twitter, but remember, people have different senses of humor, and I'll talk a little bit more about that later. When we're talking about Twitter and ethics, a crucial thing to remember is that in some states, Twitter is potentially unusable. For example, in Florida, each tweet has to have the attorney's name and the office location. The problem with that is you only have 140 characters. So even though you can use abbreviations for the office location, you still are already using up quite a bit of your characters before you can tweet. Florida is especially restrictive in its social media. In fact, there's a lawsuit right now going on in Florida over some First Amendment issues related to marketing, and both sides are submitting a request for summary judgment, so it'll be interesting to see what happens. But you need to check what's okay in your state, in your jurisdiction, and make sure you obey the rules. Facebook and LinkedIn are extremely valuable. I think a lot of people will focus on one site more than others. I think that's just what happens, and my focus has always been Facebook. It's just my preference. You want to use Facebook and LinkedIn accounts as a way to network with potential clients and other attorneys. Facebook is where you're going to go after your consumers, and LinkedIn is where you're going to go after your business. So you're going to focus on whichever is correct for you. If you do divorce law, if you do personal injury law, you're going to focus more on Facebook. If you're a business lawyer, you're probably going to focus more on LinkedIn. So you want to put your effort where it makes sense for you. Twitter is both consumer and business. People have always said to me when I first start talking about social media, I don't really care what someone has for breakfast, so why should I care about Facebook? And the answer is I don't really care what someone had for breakfast either, and when people do post like that, it's more irritating than anything else. Most people don't actually post that way. I think the way you need to think about Facebook is it's sort of like going out for coffee with a potential client, except you're able to go out with a whole lot of people at once. Just think of it that way as opposed to as a straight-out market in people's face tool. Because if you try to market in people's face, they're going to turn you out. They're not going to be interested. You need to think of it more, as I said, a friendly, networking, sharing kind of a place in which you share about yourself and about your firm as is appropriate for you. You want to create a page for your firm on Facebook. Every law firm should have a page, even if Facebook is not your primary spot of interest, because it's yet another place for people to find you. You need to understand that law firms should not have accounts. In other words, when you sign into Facebook, the email address should not be for the law firm. The account should not be under the name of the law firm. Law firms should have pages. There are two reasons for this. First is that you are violating the terms of service of Facebook if you use an account for a firm. Accounts are for individuals. The other reason is that Facebook offers quite a few tools under pages that it does not offer under accounts. So what you do is you create an account for an individual, such as yourself, and you create a page for your firm, and you create managers of that page, administrators of that page. You can then edit it and post on it and use it. So you keep your account separately from your page. You may choose to invite clients to be friends on your account. We will discuss that a little bit more later, but anybody can like your page, which means that it's public and easily accessible. And Google indexes your page as well. LinkedIn has pages as well. You should have a page for your firm on LinkedIn. You should post to that page. You should post to your Facebook page. Again, you want to share blog posts, but if you can share other information about what your lawyers and your firm is up to, all the better. Share useful articles by other people. There are a great number of ways to share not only marketing information, but useful information that potential clients will want to read. Obviously, people are not just going to want to read things, hire me, hire me, hire me. They're not interested, and you're not going to get followers that way. You have to provide useful and interesting information. You want to include your disclaimers on the pages, and there are a number of places where you can put them. I mentioned disclaimers earlier. You just want to make sure you include the appropriate kind of disclaimer for your jurisdiction or jurisdiction. So, what I do is I put, for my own personal account on Facebook, you see I have a disclaimer. This is Lowenthal and Abrams' Facebook account. You see I have a disclaimer here as well as there. So you want to put the disclaimer and you want to follow the terms of service. Best practices for LinkedIn, this is a professional site. If you start sharing personal information, you're going to irritate people, and they're going to not want to be connections with you. The whole point of LinkedIn is to share professional information. You're speaking at a seminar. You've written a blog post. Even if you've done charity work. Any of those things are fine, but you don't want to start talking about, I would never post about my dog running away on LinkedIn, for example. You don't want to spam people's private inboxes with ads. That is the surest way to get people to disconnect from you. Whenever people do that to me, unless they know me well, I'm very irritated, and I either say something to them or I just disconnect from them. You want to be very careful about disturbing people you do not know, because you can connect to people you don't know, because you can connect up to 3 degrees away, and it goes in degrees. Let's say you are connected to me, you can see who I'm connected to, and then you can become connections with my connections, and that's how it works. It goes out by degrees. It's very, very important that you be polite. You can network your way to very important and interesting people, including potential clients, including Fortune 500 CEOs. Every Fortune 500 company is represented on Facebook. But you want to be polite, and you want to watch that first impression. Join relevant groups. There are a lot of groups on LinkedIn that will be relevant to your practice areas and even potentially your hobbies. That's a great way to meet people and to engage. You're going to share useful information, and LinkedIn is a wonderful networking tool. It's a great way to set up offline meetings. You know somebody's coming to your city, say you're in D.C., somebody you follow, you could send them a message saying, hey, I see you're going to be in D.C., would you like to get together and have a cup of coffee? Whatever. So the online moves into the offline. LinkedIn has skills and endorsements. You can see here people are endorsing me for different skills. You have an obligation to make sure that any skills for which you're endorsed are in fact skills that you have, because people can endorse you for anything. So if somebody endorsed me for, I don't know, criminal law, which I don't practice, I would have to remove that. Now, you can turn off endorsements completely, but these endorsements help people find you when they're searching, so it's better to leave them on and then just every so often take a look at them and clean them up. LinkedIn has specialties under not the accounts, but the pages. You need to make sure that you don't fill out the company's specialties unless you do in fact specialize, as is legitimate in your jurisdiction, or if you are in a jurisdiction where use of the word specialize is not a problem. Otherwise, you can just leave it blank and not use it, and you can put in whether your areas of practice somewhere else. Best practices for Facebook. Facebook is all about engaging. Here's the dog I've mentioned a few times, and I talk about him a lot because it's comfortable for me. I don't like to share much in the way of personal information. Since I have over 1,000 friends on Facebook, most of whom I have never met, that means I'm sharing information that I don't care if 1,000 people see. My philosophy has always been, if you would be embarrassed if your mother, your father, and the New York Times heard about it, then don't post it. I think it's just the best way to control what is going on out there. So I talk about my dog. I talk about my work. I've even posted when I got a new chair at this job, which I started about 1.5 years ago. I posted, oh, look at my pretty new chair. And believe it or not, a lot of people commented. People will comment on the most inane things. But it's the way human beings are. It's replace the water cooler. I will share other people's posts. I'll share my own blog posts and my law firm's blog posts. I'll share random facts I find interesting. I don't generally share details about my life. because I'm not comfortable, but if you are, there's nothing wrong with that. I do get clients from Facebook. I've gotten law firm clients for my firm, personal injury, and other areas of practice, and I've gotten them for my consulting business. And I get them not because I'm marketing, but because I'm sharing myself as a person. Most people are very nervous when it comes time to hire a lawyer. And when they're connected to you on Facebook and they see you being friendly and they see you maybe sharing common interests with them, it makes them more comfortable. So as a result, they're more inclined to approach you. And this includes people I have never met, but they just feel comfortable with me, and so they think, hey, Jennifer handles this kind of practice, or her firm handles this kind of practice. I'm going to send her a message and see if she can help me out. Share interesting stuff. You want to encourage conversation. You want your page to be robust. A great way to get followers on your page is to use contests and sweepstakes with the caveat that you follow the law. Contests and sweepstake law can be very difficult, so make sure you know what you're doing. And, of course, watch the ethics rules. I've not seen an ethics opinion that says we can't use contests and sweepstakes. So if there's one out there, I'm just unaware of it. But you might want to double-check because both the ethics rules are always changing. Something I mentioned earlier, should you friend clients on Facebook? And my answer is just it depends on your comfort level. If you tend to have a very personal account, I would say no. You want to remember, if you friend them, these people are going to be commenting on your posts. If you're uncomfortable with the person or you think he or she may embarrass you, it's a very bad idea to friend them. This can be politically sensitive. Some people won't understand why you don't want to friend them. So you're best having sort of a policy. You friend them or you don't friend them for the most part. You can adjust your settings on Facebook so certain people won't see certain posts. So there are lots of ways to hide things you might not want to share with certain groups of people, so that's another way to handle it. Or you can just encourage people to like your business page and just explain to them your philosophy as a lawyer is you keep your Facebook account just to your very close friends and family, and you encourage clients to follow your Facebook page. You just have to make a decision based on that. There is no ethics rule specifically against friending clients on Facebook. However, I would say it's better off if you let them friend you and you don't friend them, because you don't want to get accused of any kind of solicitation based on the immediacy of the issue. What kind of posts are okay ethically speaking on Facebook? Confidentiality is a big one. Be very careful you don't share any information that could violate confidentiality. Even if you're talking about winning a case or something, you want to make sure that you either ask permission or you are not able to identify the person. Beware of answering specific questions with detailed advice. You don't want to form an attorney-client relationship or practice in a state where you're not licensed by answering a question from somebody in another state. Be true to your personality. Sometimes I've heard search engine optimization folks will tell lawyers to be controversial just to be controversial because it'll give them attention. That's a bad idea. You're getting attention for the wrong reason. On the other hand, you don't have to avoid all controversy. You just need to be aware of whatever the risks are when you begin discussing politics or race or religion or anything else that could end up being controversial, and understand that you could end up upsetting people who then might not want you to be clients, or might not want to work with you. So you just have to be aware of the risks. But I fundamentally suggest you be yourself. Now, let's look at some rules related to California, which has given us some very good instruction based on an opinion that they put out in 2012. Social media postings may be subject to advertising rules. It depends on the content. The wise assumption is to assume that they are all subject to the rules. In California, any communication, what is called a communication for purposes of marketing, is when you are showing availability for professional employment. Now, this is not the case in every jurisdiction. This is California. You may not use any true statement that is false or deceptive or confusing or deceptive, and that is the case across every jurisdiction. You may not omit material of facts. That is the case across every jurisdiction. If you are in California, if it is a communication or solicitation, you have to state that in the post, and you may not transmit a post or in any way that is intrusive, coercive, creates duress, or any is harassing, or any of those sorts of things. So again, that's California, but very similar to most jurisdictions. Here are some examples that they gave. Case finally over, unanimous verdict celebrating tonight. This, the ethics guidance opinion states, was not marketing because it was not a communication, because it did not offer anything concerning the available for professional employment. However, the next one, another great victory in court today, my client is delighted, who wants to be next. Who wants to be next makes it a communication, which makes it marketing. So it violates the rules because it doesn't include a disclaimer, it does not state it's advertising, and it offers a guarantee or prediction of winning. That's the big one, that guarantee or prediction of winning. You're going to find that in pretty much every state, where if you're suggesting an outcome, that's not okay. And if you're going to suggest an outcome, then you then have to have a disclaimer stating, and some have very specific things you must state, that there is no guarantee of a specific outcome, that sort of a thing. So this one is a problem, again, in California. Now, in Pennsylvania, I think that it would be less of a problem. I think it would be advertising, so I would have to follow the rules, but we don't have to include that individual disclaimer in each post. I don't have to state it's an advertisement in each post. But again, those are just different jurisdictions that handle things differently. I would have to deal with the guarantee or prediction of winning, however, without using a disclaimer. So I think this is where you might want me to break, Nadia.
Yes. So before we begin the question and answer segment, I just ask that all the attendees type the passcode that was given at the beginning of the presentation. And our first question is, how can you maintain client confidentiality on a business Facebook page if clients are the ones who are on the page?
An excellent question. If clients are on the page, that's their choice. They've made the choice, but there's no statement by the fact that they like your page that they're clients. I have over 3,000 people who like my firm's Facebook page. Some of them are clients, some of them are not. So it's just not really an issue because there's no statement by the fact that they like your page that they are clients. So I don't think you have to worry about that. Where I get into concern is when people respond to a post that I have written on the page and publicly talk about wanting to retain us. At that point, what I will do is try to stop the person from the conversation, offer to call the person, suggest that they message me privately, ask them for their phone number, and then what I do is I remove the post. I remove their content. And what I tend to do is I will remove it and I will put in a post, an answer in which I state, I've removed this information to preserve your confidentiality. I hope you don't mind. If a client, I've never had this happen, but if a client should choose to start a conversation with me back and forth on Facebook or on Twitter or anywhere else in which they are talking about their case, I'm going to stop them and recommend that they halt the conversation. If a client chooses to share information and I can't get them to stop, I've never had it happen, but if that should occur, that is his or her choice. It's a foolish choice. And even if the case is over, or even if the client is mad at me and is slamming me, I've never had that happen, but if it should, I'm going to discourage them from continuing it, and I'm going to hide it, or I'm going to delete it. That's how I deal with that sort of a thing. Even though the confidentiality belongs to them, sometimes you have to protect people from themselves. I hope that answers your question.
Okay, our next question is, do most states have the communication rule and interpret it as marketing?
Most states do not define it that way, no. Most states have not really delved into precisely what is and what is not marketing on social media. Most states are pretty lax about it. They're more like Pennsylvania, where they say, obey the general marketing rules. California has very specific rules about what is and is not communication, and therefore what is and is not marketing. I'm going to guess Florida's too. Probably Rhode Island. I haven't read their ethics rules, but they're pretty severe as well. You know, not you specifically, whomever asked the questions, but generally we know who the states are that are much, much more picky about what is and what is not marketing and whether things have to be submitted if they are marketing and so on and so forth. It's in those states where things become much more challenging. So you really want to closely look at those rules. But no, most states are not that explicit in identifying what is and what is not marketing. Excellent question.
Hi, is there a good way to differentiate between your personal social media and your professional social media?
It is utterly impossible to differentiate between your personal social media and your professional social media, and I will tell you why. When I first started using social media, I worked for an organization called the Pennsylvania Bar Institute. And as I said earlier, I joined it because a friend asked me to. She said it would be easier for her to communicate with me because she was in, I don't know, some godforsaken part of the world at that point in time. And so I did. And because I handled marketing at this organization, which was a CLE organization, I thought very quickly how useful a way social media would be to reach potential customers, lawyers. But at the same time, I wanted to have a separate private presence, personal presence, and a separate presence for the Pennsylvania Bar Institute. So I created 2 accounts. At first, I was unknowingly violating the terms of service of Facebook, which does not allow more than 1 account. But the other thing is I just found it too hard. It just was too time-consuming to keep up these 2 different accounts. So eventually, I just merged them. The other reason you cannot separate them is you really have no control in the end over who sees what. And you are still ethically obligated as to your behavior, even if you say it personally. An example is there was an attorney, I forget what state, but there was an attorney who really decided that he didn't like that a gay person was the president of the Student Bar Association of college. And he really went after him. He created a blog and he did all this stuff, and he got in trouble. Initially, his response was he had a First Amendment right, and he was incidentally an employee of the government. He was an attorney for the state or some such. And his response initially was that he had a First Amendment right to say whatever he wanted. It wasn't related to work. It didn't take too long before he got fired because of the old bugaboo of he used the work computer and therefore made it related to work. But the reality is that you create a presence online for yourself. And that presence is both professional and personal. And even if you think you have your privacy settings under control, social media is really all about sharing. And if you say something upsetting or something that might not be upsetting to your regular friends and family, but someone else sees it and decides to share it, and it ends up with you going viral in the same because you said something that was misunderstood, or it gets shared with the ethics, the disciplinary board, and it was something really inappropriate that you said. It's just impossible. The internet is a big place, and the data gets out there all sorts of ways. And so it's just not possible to keep them separate. It's my unfortunate answer to your question. Next.
Okay. Is Facebook messaging okay in certain states? This person has been told that in Florida it is not, but they're curious if you know any states where it is okay.
This is interesting. I'm going to answer it now, but I bring this up later. The funny thing about Facebook messaging is, and I had this conversation with somebody from the disciplinary board. We were teaching a seminar together in Pennsylvania. When the other person is not online, Facebook is more like an email when you send a message. In other words, it gets put in an inbox and they see it when they see it. When you're both online, Facebook messaging becomes a chat, which is more like instant messaging. Instant messaging is one of those real-time, immediate forms of communication that could fundamentally be seen as solicitation. And of course, we all know solicitation is not okay. So I would say that if you are going to begin the initial conversation with someone who is not a client, you doing it via Facebook messaging is unwise. Sometimes people contact me on Facebook through message about representation. That's normally where the initial contact will happen when they want to retain me or my firm. I very quickly guide them off of Facebook. Reason being, I am concerned about their confidentiality. While I am very careful to have a good password, and I'm very careful about where I log into my account, I do not have control over Facebook. And it concerns me to engage in any detailed conversation that could potentially be broken into either via my account or the other person's account who may not be as careful as I am. So I advise you to minimize your communication via Facebook messaging with someone who communicates with you, and I advise you not to begin a potential client contact with somebody who has not initially communicated with you through messaging. What do I mean by that? If somebody on Facebook posts on my law firm's Facebook page, hey, do you guys handle this? I have no problem either responding right then and there, yes, why don't you give us a call, here's our number, or responding via private message, we do, would you like me to have someone call you? Because that person contacted me first. You see the difference? Whereas if somebody posted on Facebook, I was in a car accident, gosh, I need a lawyer, I would not message that person because to me that would be a solicitation. In fact, I wouldn't even respond, I'm a lawyer. Normally I just respond, are you okay? And then when I respond, are you okay, normally the person says, hey, wait, you're a lawyer. So I don't even need to be that blunt. So to me, I don't like it. Minimize its use. And knowing Florida, you know what? It probably is unethical according to their rules because they're so picky. There's my answer. But you know what? That's my answer. Someone else might give you different.
Okay, those are all the questions we have for now, so please continue on with the presentation.
Okay, great. Those are great questions. Let's talk a little bit about ads. Ads are a wonderful way to increase the visibility of your various posts. Let's face it, being lawyers, we're going to have trouble getting followers on Facebook, on Twitter, on LinkedIn, on our blog. You know, we're not the Gap. We're not a charity. We are a controversial profession, and you know, we don't generally talk about things that fascinate most people. Now, if you can do that and you can get a lot of followers, that's fabulous. But if you're like most of us and you have to fight for every follower, using advertisements is a great way to increase who sees your post and even to bring in new followers. So let's say, actually just did an ad last night on medical malpractice. I posted about medical malpractice, I provided a line or two, and then I put a link back to the page I want people to see. I focused on Philadelphia, Pennsylvania. I chose appropriate keywords. What do I mean by keywords? Well, I mean medical malpractice. I mean hashtag medical malpractice all put together. I mean Philadelphia medical malpractice. All of these terms that people might be typing or searching for that relate to what I'm interested in getting people to my website to discuss. Then what happens is people who, I have about 300 or so followers on Twitter for my law firm. I'd have to look to see the exact number, but I think that's what it is. And what I can do is I can choose the geographic location, I can choose the posts I want to be marketed, and I can choose the keywords. I could also limit by gender, language, and all sorts of other things. And then more people will see this. How much does it cost? Well, most of these things are pay per click or pay per view. And the cost on Twitter ranges from about $1 to about $2.50, depending on the demographic. And that's per view. Ads on Facebook. Facebook has two kinds of ads. They have regular ads that show up on the side and show up in the timeline, and the timeline is what people see as they're looking at Facebook. And they have sponsored or boosted posts. The difference is that a boosted post can be pretty much as long as you want it to be, and it's something that you've written on your Facebook page. And then you tell that post, you tell Facebook, I want this to go to people in these cities of this age range who have these interests, or you can even use email addresses that get matched to Facebook accounts. And then Facebook shows to those people. To get you to understand the difference, on a good day of my 3,000 some odd followers on Facebook for my firm, maybe 300 or 400 people will see a post. If I sponsor or boost a post, I can get 30,000 to 40,000 people to see it. If you have the budget, it's worth $100, just a couple $100, to get a really good post seen using this tool. Now, ads are a little bit different. This is an ad, and one of the ways you can tell it's an ad is because of the layout. First of all, you have very little writing to do. In this case, you only have a certain number of characters. It's very focused. It's very explicit. But you target it the same way. You can connect an ad to your Facebook page as a way of driving traffic to that page and hopefully increasing likes. Or you can drive traffic to your website to increase your traffic and hopefully obtain leads. That's how ads on Facebook work. Ads on LinkedIn, they're very similar. I have not had as much success with ads on LinkedIn, though I have not tried them in quite some time. You can purchase them much the same way. The costs vary. Facebook, by the way, the costs vary from a couple bucks to quite a bit more. LinkedIn is similar. You can also target by job title and industry on LinkedIn. It's actually a little easier to target more specifically on LinkedIn than it is on Facebook. I find that for lawyers, targeting by interest is very challenging because what's the interest of somebody who was in a car accident? You know, that could be anything. So that makes it a little harder to target. But if you want to target business people, you certainly can do so on LinkedIn, and I would commend it for that purpose. Let's talk about ads and ethics. Are ads on social media okay? I have not yet seen an opinion. However, pay-per-click, which is what these are, have been done on Google for many, many years. So I would say you need to look at your state and look at whether it requires the disclaimer to be on the ad, because you're not going to have space to include the disclaimer on the ad. The ads are too small, with the exception of a boosted post on Facebook. Then you could put it there. So if the ad must have the disclaimer, I would say that you can't do it. If the ad does not have to have the disclaimer, then you can do it. So you need to look at your rules. The way I have interpreted this, and it seems to be okay, is that in my state, I always make sure that there's a disclaimer on the page itself. So as I said, I have a disclaimer on my firm's LinkedIn account and my firm's Facebook account. And I link to the disclaimer, and that seems to work out just fine. So that's how I've interpreted it. That's how I've used it. Knock on wood, I have not gotten in trouble, and hopefully I won't. And if I do, I simply will have to explain that this was my philosophy on it, and this is why I approached it this way. But for the moment, since Google is okay, and my state actually has said in ethics opinions, which are not binding on the Supreme Court, but has said in ethics opinions that that it's okay to do this, I figure it's okay to do it this way. Now, somebody asked that I'm going to answer right now, Is your Facebook advertising limited geographically? If not, how do you limit contact to those who you are licensed to serve? Yes, I limit my Facebook advertising geographically, and it's quite easy to do so. And I recommend you do so, both for the ethical reasons and for the cost. It's much cheaper if you can control where you market, and there's no point in marketing to people that you don't want to hire you. Very good question. So we talked a little bit about solicitation with the person who asked related to Facebook messaging. So just to sort of quickly go over it, a solicitation is a targeted communication. In other words, you're pointing to a specific person where you're offering to provide legal service, and it's there's an immediacy is when it's not okay. So picking up the phone and calling, sending an instant message, we went over the issues with Facebook Messenger. It is okay in every state to use a billboard, to use internet banner, to use a general ad, because these are not to specific people. So you aren't allowed phone calls, you aren't allowed instant chat, you aren't allowed to walk up to somebody, in court, but you are allowed to use email, websites, banners, social media posts, general chat rooms. Again, check with your jurisdiction. So I already talked about the Facebook issue, as you can see. I explained the issue there. One thing I did see, and that disturbed me on Twitter, was there was a firm out of Florida that was targeting specific people, or rather a specific hashtag related to an event. People, as I said earlier, will share information about a hashtag. So let's say, for sake of argument, there was a major car accident, and everybody was sharing hashtag car accident, and everybody knew what this referred to. So this firm did hashtag car accident, call us if you need legal assistance. Now, I mentioned this on Facebook because I found it to be crass, personally. Other people might not, but I found it that way. And some people said they thought it was perfectly appropriate, but crass, and some people thought it was perfectly appropriate and not crass, and some people felt it was a targeted solicitation. Regardless of whether you think it's okay or not in terms of the emotionality of it, you want to check with your own jurisdiction to see if that might be considered a targeted solicitation. I have concerns that it might be seen that way because you are specifically asking people who were in that specific event to contact you if they need help, though you did not directly contact them. Now, if you use the handle, if you use @JLE_JD after I was in a car accident and send it directly to me, I think that would be a solicitation. But again, people might disagree with me because it's not real time. Let's talk about the attorney-client relationship. This is an issue to be aware of when you're talking with people on social media. What is an attorney-client relationship? It's when somebody has an objectively reasonable belief that you are handling his legal interests. So if you cause that belief to rise, you are going to inadvertently form an attorney-client relationship. And if you cause that belief to rise in a state in which you are not licensed, you have now engaged in the unauthorized practice of law. Now, I have no problem answering questions online. I answer questions on Avvo. I get clients from it. I also just like answering questions because I like helping people. But I'm careful to give general information instead of being extraordinarily specific. And that's what I recommend. And again, you want to make sure to include disclaimers in your general accounts and pages that make it clear that they are not forming an attorney-client relationship and that you are not providing legal advice. Body language is a big issue in social media, joking, and as I said earlier, it's fine to joke, but you've got to be careful. This is a famous incident where an Indiana deputy AG was fired because he tweeted that they should clear the Wisconsin clear a Wisconsin building when there were protests over union issues, and they were going to use rubber bullets, and he said they should use live ammunition. So clearly he was joking. It was 3 in the morning. He made a stupid comment, but he lost his job. First of all, no good comes from a tweet at 3 in the morning. But leaving that aside, a joke to you might be a threat to someone else. So that's, again, why you have this personal, professional thing you have to worry about. Some general business concerns. You want to encourage your firm's attorneys to use social media, but you want to have clear policies on what is okay and what is not. You want to encourage someone to keep track of all social media for the firm. You want to be prepared to respond to problems. You don't want to have to create a policy on how to respond after a problem has happened. And you want to empower someone to respond in emergency. Now, if I have somebody who's being obnoxious on Facebook, I sometimes will engage them in comments if I feel that I can and it'll be okay, or sometimes I will just hide the message so nobody but that person can see it. And then sometimes I'll delete the message and ban the person. I have the power to do that. I have been given the power to do that. You need to decide who has the power to do such things and what your response will be. Whatever that response will be is fine. You just need to decide what it's going to be. Make sure your employees understand that they are not allowed to post on your behalf unless it's part of their job. And also make it clear that a violation of client confidentiality will be punished. I believe termination is the only appropriate response to that. And remember, you're responsible for your employees' actions under Rule 5.3. So my final thought, although there can be risks to using social media, those risks can be minimized. And the risks are worth it due to the fact that it is such a powerful marketing tool. It's a powerful marketing tool because social media is where the people are. Hundreds of millions of Americans, over 1 billion people across the world use Facebook, 1.3 billion. Over 300 million people use LinkedIn. Over 500 million people use Twitter. People use social media, and given that, that is one great way to reach them. Pretty much everybody we're trying to reach uses the web, and that's why it's important that you have a presence. Just be sure that your ability to have a positive effect and your ability to have a negative effect are both increased by the potential for people to see you. So you get more bang positive for your buck and more bang negative for your lack of common sense or your lack of employees' common sense when using Facebook and other sites. Obey the ethical rules, obey the advertising rules, and encourage common sense on behalf of those who are posting on your behalf, and you should be just fine. Questions?
Okay, could all the attendees please type the passcode into the chat feature once again? And our first question is, does malpractice insurance typically cover social media marketing ethics violations?
Very good. No, it does not typically cover it. You need to check your policy. Some do, some don't. You have to read it, and if it's unclear, you have to ask.
Okay, and are there resources for staff to go for training on social media?
A lot of CLE organizations offer training. A lot of consultants offer training. I would say you can look around and find some options. Yes. Any more?
We are checking through the list right now. Let me see. What are Facebook and Twitter responsibilities if your account is hacked?
Facebook and Twitter have minimal responsibilities, sorry to say. I have known people who had their accounts hacked, and Facebook was very responsive and Twitter was very responsive. And then I have had people who have had their identity stolen, other people created the account or hacked it, and no matter what they did, they ended up in this weird Kafkaesque experience of Facebook refusing to cooperate, no matter how much evidence they provided that they were who they said they were. Listen, Facebook and Twitter have a lot of money, so you're not going to sue them, most likely, over an account being hacked. And sometimes a letter or a communication with somebody who has insider access to Facebook, that is not me, I don't have that kind of access, is what I mean, might help resolve the problem, and sometimes not. Fortunately, more often than not, if your account is hacked, you can prove who you are and regain control. However, with Twitter, if your handle gets stolen, and this has happened, and they were really good at it, there have been occasions where the person could not get the handle back.
Okay, and is there somewhere you can find a sample of a disclaimer to put on your social media page?
You are more than welcome to look at my firm, Lowenthal & Abrams, on Facebook and on LinkedIn. There is not one on Twitter because there's no space.
Okay, our next question is, how prevalent are ethical violations with respect to social media?
I think they're very, very prevalent, but I don't think it's intentional, and I don't think the disciplinary boards are paying too much attention yet. I think that more and more states are writing opinions that I think will help. Pennsylvania just released an excellent opinion on social media, and I would commend it to you. It's the PBA's website. So you have to be a member of PBA at that point. I understand they're going to open it up soon. But if you look up Pennsylvania social media opinion, you should be able to find at least some discussion of it. Philadelphia also has a very good social media opinion. San Diego has a great social media opinion. So there's quite a few out there. New York has a number. So I think as people start to see more and more opinions and more bar associations offer opinions and people attend more seminars, they're going to learn what's appropriate and what's not appropriate. But I do see a lot of violations. Yeah.
Okay, those are all the questions that we have, so we're going to continue on with the CLE information. This webinar is eligible for CLE credit in California, Illinois, Minnesota, Missouri, New Jersey, Pennsylvania, and Texas. To ensure that you receive your CLE credit, please complete the survey at the end of the presentation. In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and document management solutions, free interactive webinars, research reports on expert witnesses such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Jennifer Ellis for her time and effort in creating this presentation. If you would like to speak with Ms. Ellis, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. This is a reminder that we will be sending out a link to you tomorrow with the archived recording. The archive recording will also be posted in the Knowledge Center on TASA's website. If you have any questions or comments, please email Carol Kovalevsky. Thank you all again for attending today, and have a great day, everyone.
Thanks, everyone, for listening, and thank you to TASA for having me.